This is video 2, weeks 11 to 12, outline of motion practice in orders to show cause. And we focused on motion practice in the first video, and now I've turned to the, I believe it's this, it is the second page, order to show cause. And our order to show cause comes into play when there's an emergency need for judicial relief. And let me try my hand at perhaps identifying a couple of different ways that might arise. Let's assume that there's a school district and a teachers union, and the teachers union is threatening to go out on strike, which, by the way, is illegal under the laws of the state of New York. And the district, even though it's illegal, wants to get a court order directing the union not to go out on strike. And by the way, if you get a court order that prevents the union from going out on strike, and now if the union does go out on strike, its president, at the very least, has violated a court order, which is a basis for contempt of court and a basis for going to jail. That's happened before. So that could be one situation where there's a need for emergency relief. Maybe we have a situation where, and this would be a proceeding where the Department of Health has summarily suspended a physician's license to practice medicine. And the physician wants to go to court and get an order that would stay, meaning the suspension couldn't be enforced, stay the application of the suspension order. And I remember one case like that where the physician was an oncologist and he was actively treating patients who had ovarian cancer. And one of his therapeutic regimes for a number of his patients was administering chemotherapy on a regular basis. And if the order had gone into effect, or the summary suspension, his patients would have been without any medical care. So certainly there was a perception there of an emergency need. We could also think of a divorce case where the non-custodial parent gets wind that the custodial parent, while the case is pending, is thinking of moving from the area. And if that's the case, I'm going to tell you that that non-custodial spouse is going to perceive the need for emergency need for relief. When I say emergency need for relief, we can't wait for the regular motion practice to get us to court. It's not going to be fast enough. I don't think it's a great idea to burden you with a lot of time limits, but I can tell you that from the day I file a motion until the day it's going to be returned to court, that's going to be anywhere from 2 weeks to a month, typically. If you consider the three examples I just gave you, we really need to get in court if we're representing the non-custodial parent or representing the physician. By way of example, we need to get in court like yesterday. This is just this emergency need to do so. So let me just add something too. I think there's been a change in the practice of law. I always thought orders to show cause were overused. I never liked them unless they truly was needed, because, in our office, when I say our office, I'm thinking even hypothetically, if we've got to respond to an emergency, that means we're dropping everything else, and we're reordering our time, and we're possibly putting the support staff in a position of saying, well, you've got to hang around tonight until we get these papers filed, and everything else that goes with an emergency. So I think it's a good idea to keep emergencies, responses to emergencies, to true emergencies. In any event, we need to get to a judge right away. So the first thing that's going to cross our mind if we're beginning to think of the need for an order to show cause is to check to see if there's a judge assigned to the case. In federal court, there will be. In New York State Supreme Court, maybe there is. If there isn't, we're going to have to file a request for judicial intervention right away. We're also going to then be preparing the papers for the order to show cause. We have a proposed order to show cause. And I apologize I typed this very quickly, and unacceptable, by the way, so I apologize for the misspelling. And then you see I have a TRO likely, and TRO means that there's going to be, in the order to show cause itself, an order preventing the other party from doing something, like going out on strike, like moving from the area, like enforcing its summary suspension of the license to practice medicine. And so TRO means temporary restraining order. Then when I say the rest of the papers, we're going to do our supporting affidavits, exhibits if needed, memorandum of law. And again, we're really under the gun here. So this is pretty heavy lifting that we're doing. Now, once we are armed with the papers, we're going to file them, but we need to get in front of the judge so that the judge hopefully signs the order to show cause. And this might be a same-day deal. I've had them where we get the papers ready and filed first thing in the morning, and by noon we have appeared in front of the judge to present the order to show cause. Now, traditionally, the order to show cause procedure at this juncture is ex parte, EX space PARTE, meaning it's only one party. But what's happened in the last 20 years is that the court rules have changed so that notice has to be given to our opponent. It doesn't mean that our opponent is necessarily going to be given the right to present papers at this point in opposition to the proposed order to show cause, but the judge is going to insist that the opponent have some type of input. And back before the pandemic, you might be sitting in the judge's chambers if you're presenting the order to show cause and your opponent is on a speakerphone. But the judge is going to want to hear from the opponent, and if the opponent isn't available, the judge is going to want a very good reason why not, and the judge is going to expect that you can demonstrate how much attempt at notice you've made. So the judge then typically is going to hear from the opponent, hear from the attorney presenting the proposed order to show cause, and it is hoped that what the judge will do is sign the proposed order to show cause, and when the judge signs it, it's no longer proposed, but it is an order to show cause. It's a judicial order. So if the union president now, after he gets served with the order to show cause, wants to go on strike, I can guarantee you that at some point he's going to go to jail. So go have a judicial order. And what the judge will do when the judge is signing it, the judge is going to put a return date in it, and then at a later time, just like motion practice, the lawyers will show up in front of the judge and argue the relief sought. But in the interim, we can have a TRO, and if the judge doesn't want to issue the TRO, the judge is going to accelerate the return date, so maybe it's in 2 or 3 days. So this gives you a sense of the order to show cause procedure. And you can look at a posting I earlier put up of a skeletal outline of an order to show cause, so you can get a sense of what one looks like. So that'll end this recording.